Janice Heisel mainly writes in-depth reports based on U.S. political news and cultural trends. Following a 2-year stint covering President Donald Trump's 2024 reelection campaign. Before joining the Epoch Times in 2022, she worked more than 2 decades as a reporter for newspapers in Ohio and authored several books. She is a graduate of Kent State University's journalism program. Please welcome Janice Heisel.
Hello, hello. It's awesome to be back here at Empower You. I've been here several times now, and I believe so much in the mission of this place. Thank you for the great introduction, Betty. So I am here to talk about what I like to call Minnesota mayhem, the Minnesota fraud, all of the ICE protests and everything. And I'm going to try to do, maybe I'm a miracle worker up here, I don't know, but I'm going to try to help you understand and make some sense out of it because it is kind of mayhem, right? So, I don't have all the answers, but I can give you some insights from some reporting trips that I've done. And I've been there. My poor husband, Michael, here in the front row, has been abandoned by me quite a few times while I've been in Minnesota trying to figure all of this out. But what I'm going to tell you today, I'm going to tell you, number one, how the fraud and immigration issues are actually related and how it all got so bad. Then I'm going to talk to you about what's being done, how it's actually affecting Ohio and the nation, and what can you do as a citizen. So that's a lot to cover in 20 minutes. I'll do my very best to keep this rolling. So how did we get here? I'm going to start with a few events that happened late last year. How many of you heard about the video that was done by a young man named Nick Shirley? I thought just about everybody would because it's out there everywhere. But even before then, there was a lot of stuff going on, and I was part of some of it. Actually, in September, the U.S. Attorney in Minnesota announced some additional Somali fraud scandals and new arrests. All of this investigation dates back to 2021. They started indicting people in 2022. So this has been ongoing for several years before most of us ever had any clue, right? So it didn't just come out overnight. It's just now that we're paying attention. So in late November, so fast forward from that September, now we have late November, the Manhattan Institute took some information from that, and they produced a really good investigative report that said Al-Shabaab, the terrorism group in Somalia, a lot of the people who were charged in this scandal were from Somalia, actually was getting a lot of money from all the fraud. And so that really got the attention of the Trump administration. So in early December, the Trump administration really ratcheted up the investigations of immigration enforcement, fraud investigations, and ended the Somali protected status, which is a move that some people think was way overdue. Other people were outraged over it. So that we got both sides of that. So as for me, I started digging into what was going on behind the scenes, and I kept wondering, why Minnesota? What is it about Minnesota that caused all of this? And the result is the project that you see on the backdrop behind me, How Minnesota Nice and Progressive Policies Paved the Way for Somali Fraud. How many of you ever heard of the term Minnesota Nice before? A couple of you? A few of you? Yeah. So I'm here to explain that a little bit, what I found out about it. So Minnesota Nice, it's a term that's been used for quite a while now. And actually, believe it or not, there's a type of granite called gneiss, G-N-E-I-S-S, that some people think it could be related to. But really, it's more of an attitude of, I want to help you. I want to make you feel welcome. Okay, so there's this attitude like that. And it comes from the Nordic regions of the world came and settled. A lot of those people were from Denmark, Sweden, places like that, and settled in this area and brought that same kind of attitude with them. There's a saying, though, there's a limit to Minnesota Nice, that Minnesota Nice means a Minnesotan will give you directions anywhere, gladly, everywhere except to their own front door. So it only goes so far. So that Minnesota Nice is a key part of what I'm about to share with you. So then we did have I'm digging into this and I produced this report, which predates that Nick Shirley video that went viral. So it's really not true that media weren't doing their jobs. I'm actually kind of a Janny come lately here. There were many reports dating back a decade, but the internet and the social media didn't have the influence and the reach that it has today. And I think that's a big part of why people were not paying attention, because some of those outlets did some of the very same reporting that Nick Shirley did. So I just would like to point it out that it actually was out there. We just weren't paying attention, didn't know about it. So this whole help thy neighbor, Minnesota nice attitude is a high trust culture. And I learned that people in Minnesota, they don't want to question if somebody says, I need help, they want to help. And I can commend people for that. Help thy neighbor. We've all heard that. We all believe in that, I hope. But maybe that neighbor wants to take advantage. And you also have to kind of worry about that potential. Also, part of the Minnesota nice attitude that I came to learn was that if someone offers to be the helper, we don't want to question that either. So that those people might be taking advantage of the system and collecting money for benefits that they're not giving. So all of that became part of this fraud. Does it make sense now that how that could possibly be? I hope it does. And there's also a belief that taxes are worth it to pay for all these programs because it makes society better. But then at what cost when people take advantage? That's the problem. So this morphed into Minnesota nice on steroids, in my opinion. I don't give my opinion a lot, but that's one I will stand by. But it's been combined with some outside influence and possibly some funding, which still remains under investigation. There were threats of racism. You're racist if you want to investigate Somalians. You're Islamophobic. So again, it all kind of just developed on steroids behind the scenes. And then we had silencing of the whistleblowers with those threats. Whistleblowers who worked in some of these government agencies, they were going, wait a minute. There's no justification for this huge amount of money going to this organization. We need to look into this. Oh, you're racist. Shut up. And actually, some of them were surveilled, which is crazy to think about. Some of them were demoted, lost jobs, just a lot of really, really difficult consequences for those people. So you mix all that with a few dashes of political influence, because in some of the elections in Minnesota, the Somalis' vote has become very important. And so there's a lot of reasons for politicians to want to keep those people happy. And then there are allegations that there may have been some corruption involved or even criminal conduct, which is still being investigated. So that's where we are. James Comer, who is the head of the Oversight Committee in Congress, in the House of Representatives, said this: while whistleblowers were silenced, fraudsters got rich. Kind of sums up the situation. The payments kept flowing, and he questioned the governor, Tim Walz, and also the attorney general, Keith Ellison from Minnesota, about this. Payments literally kept flowing even after these fraud alarms came out. In one instance, there was an organization that received $307,000 the year before Tim Walz took office. 2 years later, that number ballooned to $200 million, up from $300,000. Wouldn't you think that there might be you'd have to really look into the reason for that big increase? So here we are. Now, what is being done? We're having a full court press of federal departments. We're talking the Treasury is looking into those Somali fund transfers, possibly to the terrorists. We've got the IRS involved. We got the Health and Human Services, FBI, ICE, Border Patrol, Small Business Administration, Medicaid. And importantly, and very controversially, money is being cut off when there's been suspicion. And there's been a lot of back and forth between the Trump administration and the state officials in Minnesota over those funds being cut off. So then we have the anti-ICE protests. A lot of those people really do. They believe in their hearts, I think, that, they're trying to help their neighbor, that help the neighbor on steroids thing that I mentioned. Some of them, though, there is reason to believe that some of them may be getting paid, and you kind of mix all of that together. And you just have the unfortunate situation that exploded into a couple of deaths. Just really, really awful situation all around. Nobody wants that. So now we have this situation where all of the attention in Minnesota caused other states, people in other states, to start looking, including here in Ohio. How many of you are aware of fraud concerns in Ohio now? Okay, quite a few of you. That's good. I actually took a trip up to Columbus and did a report there as well. I was able to find one employee of a daycare who is Somali, and on promise that I divulge who she was. She did tell me, yes, that it's going on in Columbus, Ohio. There's a very large Somali community there too. And again, nothing against the Somalis, but it starts to be kind of a cultural, this is how we do it kind of attitude, is what I understand. So just like a lot of Vietnamese people learn to do nails, maybe, it can be a cultural thing. And that's not only as racist to acknowledge that there are cultural differences, right? So on my report and all the other reports are still things are still kind of emerging here in Ohio and elsewhere. California, there's been some things coming out, just a lot of different places. So interestingly, at the state level, I want to explain in Minnesota, the state lawmakers, and two of them are pictured right there, the guy in the red tie and the guy in the blue shirt. I interviewed both of them. Those guys are working really, really hard to try to get to the bottom of this fraud. And they have a lot of opposition because they're going against, again, that attitude, you're racist and everything like that. And what some people, they're not on the fraud committee, but I also spoke to people on this fraud committee that's been working for over a year to try to root out the causes. And you will not believe this. They had a lady come in who's the head of the budget for the whole state of Minnesota. And they were asking her about how she puts in place safeguards to make sure that programs are not being defrauded. And then they asked her, okay, so when one of the departments that's, many state departments that involved with these programs, if they do not follow your protocol, your rules, the safeguards, how do you hold them accountable? Do you know what the response was? We don't like to talk about accountability. We prefer to say we find ways to support. Yeah. And that was the reaction I saw. What over here? That was the reaction in the fraud committee, which I did intend to attend in person. Another thing that fits with that same mentality, during a recent congressional hearing about this, some of the employees had come forward and explained that there are actual memos, there are documents proving this, that their supervisors, like in the state welfare agency, told them that they need to operate with a mindset of 70% compassion and 30% compliance. 70% compassion, 30% compliance. So how is fraud related to illegal immigration? So I want to try to explain that a little bit here. At some congressional hearings, I didn't attend these in person, I just watched them online. They revealed some new information showing that the Somali welfare fraud problem's magnitude has only just begun to surface, like the proverbial tip of the iceberg. And a former immigration judge, Matt O'Brien, pointed out that immigration-related fraud represents a large and largely unacknowledged share of the nation's fraud losses. Many people, and I think this is the fault of the media partly, do not realize that as soon as a person enters the U.S. illegally, that's not the only violation of the law they're going to ever do, right? Because to stay in this country and maintain life in the United States, they have to do other illegal things to stay here. For example, identity theft, false citizenship claims, Social Security fraud, tax fraud, maybe even voter fraud. So there's a lot of different types of fraud that one illegal immigrant may end up committing throughout the course of his or her lifetime. Make sense? That's why this is all tied together. Also, at the same time, we have migrants that are facing pressure to succeed, maybe to send money back home. And they're coming from nations where fraud and corruption are just an accepted part of life. So it's kind of like they don't maybe know any better, that it's not okay to rip off a government program, that are, maybe you're a sucker if you just, follow the rules, right? And so if everybody else is getting theirs, why don't I get mine kind of attitude, right? So yet at the same time, the result is widespread, repeated fraud that touches nearly every part of our government system. And that's why, beyond some of the things that make the news, that the illegal immigration is so impactful. So, at the same time, data is scarce. There's no coordinated federal strategy for detecting and prosecuting immigration fraud. The responsibilities for that are scattered across, get this, 7 federal agencies and multiple state departments. So, the former immigration judge who testified, said that part of the solution could be to try to use AI, artificial intelligence, to recognize and analyze fraud patterns. So I thought that was an interesting suggestion. So, where does this leave us? And what can we as citizens do? As a reporter, a lot of times I hear frustration from people, and I feel it as a citizen of this country and a taxpayer myself. It feels like nothing ever changes. Yeah, they're investigating. Yeah, all right. I feel that. I experienced that myself. We hear about all these reports, all these investigations, public statements back and forth, and another strongly worded letter. Right? But I think we need to keep this in mind. As I've outlined here today, this problem didn't start overnight, and it's not going to be fixed overnight. I think that would be an unrealistic expectation. So, legal and policy change do take time, especially in complex cases involving federal and state agencies. I think, though, that progress happens. It's just too slow for us to notice it sometimes, probably at a snail's pace. But a policy review, a court ruling, or just a small enforcement change can really make a difference. For example, one of the Congress members did propose that there needs to be a change on a form that the people at the airport use about money being shipped out of the country. Right now, they don't even have to say where they got it from. They just have to declare that I got it and I'm sending it. Wouldn't that be a nice way to quickly change that? He's proposing some legislation that would just change that form and the procedure, basically. It seems like that part seems like a fairly easy but impactful fix, right? So here's what each of us can do. Just by being here, places like Empower You, you stay informed, and then you share this accurate information with everyone you know, everybody who will listen, everybody who you think might care. That is so important, to share verified facts with friends, family, and whatever your social networks might be. Participate in civic processes. I think people often underestimate the power of engagement other than standing and waving a sign at a protest, right? Contact your elected officials. They really do pay attention. It doesn't feel like it does. But if enough of us do it, maybe one phone call is not going to do it, but a whole bunch of them, they do start to pay attention because they know that translates into votes. And if they want to stay in office, or if they just really maybe are trying their best to go by what the constituents need and want, they can be moved by that. Vote. Voting in local and national elections for candidates whose platforms reflect your values on justice, civil liberties, and community safety is so important. It breaks my heart to see voter turnout so low in so many elections. Sometimes people feel they're powerless, but that is the one power that you really, really, really have as a citizen. And I was raised in a household and a school system that taught me it wasn't just a right, it was a duty to vote. And I take that to heart. I don't think I've ever missed, I think I missed one primary election one year of my entire life. So, and then the other thing you can do is donate to places like Empower You, volunteer with groups whose values reflect your own. I really hope also that you would consider, if you haven't already done so, take a picture of this screen listen for me on Mike Allen on Saturday mornings. I do talk about a lot of my reports there. There is a link up there for a free 30-day subscription to the Epoch Times. We are a nonprofit organization, and I've been in the news media for over 30 years. I have never worked for an organization that impresses upon us so much the importance of being as neutral as we possibly can, as balanced as we possibly can. And I can tell you, I try at my very hardest, and my editors hold all of our feet to the fire on that. So I'd like to leave you with this thought about all of this. All the small things that you can do and how they can add up. In the words of Jacob Riis, a journalist and social reformer, look at a stonecutter hammering away at his rock, perhaps 100 times, without as much as a crack showing in it. Yet, at the 101st blow, it will split in two. And I know it wasn't the last blow that did it, but all that had gone before. Thank you very much for your attention. I would like to answer any questions you may have.
Just a second.
I kept it to 19. Woo! Victory over here. That's hard for me.
Thank you. I am a subscriber to Epoch Times.
Oh,
and I
thank you.
enjoy it very much. So thank you.
I'm so happy to hear that. Thank you.
What is J.D. Vance doing since he's supposed to be fraud czar now?
That's pretty new. And so that part of it, I've actually been distracted on some other projects, but that's part of what I'm going to be delving into next. I apologize. That's not something I'm up on at the moment, but I think it's sort of just being planned out and everything right now as well. It's just taking shape from what I understand. But I definitely will be looking into that, especially since J.D. Vance is one of our own here in Ohio. And of course, this fraud, I think we all feel the weight of it. You know, I just sense that. It's just people don't feel like they're taxpayers. They feel like they're fraud payers because of all this. I was just telling my husband about that. You know, I feel that way. So yeah, great question though. Thank you very much. I definitely, now you're holding my feet to the fire. I got to check into that. Thank you.
We got time for one more question if there is one. Just a second.
Oh, on Saturdays, it's not a regular time that on the Mike Allen show. It's kind of, it fluctuates based on his schedule and mine, but he's on, I believe, from like 9 to noon or 9 to 11 or something like that. 9 to noon? Is that right? 9 to noon?
You're on a lot of times at 10.
I am. Hey, truth be told, I'm a fitness instructor and I teach from 8:30 to 9:30, so it's never going to be before 9:30. So it's usually at 10 right after my class. Yes, sir.
My name is Todd,
Hi.
and I want to share. I don't have a question, but I have a quick share of experiences that if you have local councils or city councils or school boards or boards of county commissioners, just even if you can visit them online, but go to them in person. Just get used to going to them, even if you don't have anything to say. And you might meet some people, like-minded people that you might talk to afterwards and get in touch with that you wouldn't have gotten in touch with otherwise. And so just get in the habit of going there and being seen, get comfortable with it. And then when you have something to say, you'll be more effective.
Well, that is great advice. Thank you so much. And thank you everyone for your attention. I hope that you walk away today feeling like I've made a little sense out of the Minnesota Mayhem for you. Thank you.
Thank you, Janice. You were great as usual. I think this may be the third or fourth time we've had here. By the way, Janice is the author of a book. What was the one with Widmer called?
Yeah. So that book is called Submerged, Ryan Widmer, His Drowned Bride in the Justice System. I did cover all 3 of the trials for the Cincinnati Enquirer. For those of you who remember, that was quite a few years ago now. But Ryan is still in prison. I'm still in contact with him as well. So there's some interesting things going on in the background there.
Yeah, it was a great book. If you like to read, you might want to pick one up. But Janice, thank you for coming. We certainly appreciate it. Bob Jewell is our next speaker. He's a Range Master Advanced Certified Handgun Instructor, a graduate of FBI Citizens Academy, and a graduate of the Law of Self-Defense Instructor Program. He annually participates in firearms training from top national instructors and has taught over 600 hours of concealed carry and advanced concealed carry classes. He was also influential in writing 2 Ohio self-defense laws and has authored numerous articles on tactical shooting and self-defense for national publications. Bob is also the leader of his church safety team. Let's please welcome Bob Jewell.
How's that sound? All right. It's funny, as I listen to the presentation, I don't want you to think that what I'm going to present is a solution to that. But it was a thought that crossed my mind. Mike, okay? Everybody? Good. Thank you. Betty, thank you. And it's an honor. One quick disclaimer. I'm going to talk about some legal things tonight. I'm not an attorney. I'm not going to give you legal advice. I might hit on the edge of it a little bit. Obviously, if you need legal advice, go see a licensed attorney. But you can't get into this topic and not touch on some really close edges of legal issues. And then the other thing I wanted to share with you up front is whenever I teach a class, I always start out with this. And I was just thinking I should remove the word license now since we're in a constitutional carry state and replace it with the word decision. So a decision to carry a handgun is a serious responsibility. You're carrying a highly consequential solution to a very narrowly defined problem. And I usually just let that sink in for a minute. A highly consequential solution to a very narrowly defined problem. And it should be taken seriously that way? Good. Quick history. I wish I had more time to do this because this is fun. Concealed carry actually started in Ohio in 1974. There was a law passed. It was a very poorly written law, but a citizen with no record and with some legitimate reason, like maybe you're transferring a lot of money from your business to a bank at night, could carry a concealed gun, a concealed weapon. Problem is, it was so poorly written that police were pulling over people with guns and that had legitimate reasons, and they were letting the courts sort it out. So it didn't go well. And sometimes I get my dates. So in 1996, the House and the Senate passed in Ohio a concealed carry bill. Governor Voinovich said he wouldn't sign it. So they didn't present it to the governor for signature to avoid the embarrassment. We would have had concealed carry in Ohio in 1996 had that been passed with a licensing process. So it would have fixed the problem that came from 1974. Eventually, in 2003, a Supreme Court case called Klein versus Lease. Those of you that remember, Lease was Hamilton County Sheriff. Had coffee with Chuck Klein a few weeks ago. He was telling me about it. Just to whet your appetite, we really have concealed carry in Ohio now because of a 29-year-old pizza delivery driver who got arrested, had been robbed a couple times, legitimately carrying a handgun under the older law, and got arrested, said, you'll go to court. The judge found him not guilty. There was not a jury trial as a judge. And the judge said, there's a problem with the Ohio law. It's terribly written, needs to get fixed. So Chuck Klein got together, filed a lawsuit against Cy Lease. That went all the way to Ohio Supreme Court. Ohio Supreme Court said Ohio's law was terrible and needs to get rewritten. That's what led our legislature to, in 2003, write the law that got signed by the governor in 2004. So in January 2004, Governor Taft signed House Bill 12, which made Ohio the 46th state to have a concealed carry process that involved training and a license. Instead of just saying, if you're law-abiding, you have a legitimate reason, you can carry. No, get in line with some other states. So could have had it sooner, but I think the history, to realize that the history is really on a 29-year-old pizza delivery driver who, ironically, I discovered for 14 years I've known him. And didn't know that he was that guy. And when I called him and said, Pat, I've known you for 14 years. Why didn't you ever tell me this? He says, I just don't talk about it much. He was the 29-year-old pizza driver that decided to be, for the sake of a better word, the guinea pig that would go to court, risk the fact that a judge could have found him guilty, which was a felony. Now, then it would have gone through an appeals process, but in the meantime, you're serving time. But he agreed to do that to eventually become the case that would bring us concealed carry. So it's always interesting how that takes place. So a quick question for you. How many Ohioans have a concealed handgun license? Any guesses? About 1 million? Anybody want higher or lower than that? Higher? Not much higher. About 1.1 million. And that's about 20% of our over 21 population, which is considered a maturity point in most states. When you get that many people that are of legal age to carry, you've kind of hit a maturity level in the state. It may fluctuate a little bit, but not too much. I'm an engineer, so I like graphs. Sorry, let me go backwards for a minute. And I like history. That's the number of people that have gotten licenses in our state from 2004 up to recently. You can see that when we passed constitutional carry in 2022, it's obviously dropped off, and that is to be expected. I think the other high points were our election years, where people are so concerned about what's going to happen. Let's go out. I mean, look at one year we topped over almost 120,000 people in 1 year got a concealed carry license. Last year in Ohio, 13,000 people got a concealed carry license. And that's in a state where you don't even have to take the class and get the license anymore. The other interesting thing about last year is 63,000 people renewed their license. I find that an interesting number because they don't have to renew. But 63,000 people that had a license that could have said, hey, you don't have to have a license anymore, went and renewed their license. And listen, if you have a license, I would certainly advise you to renew it. It's certainly a good idea to go to a class. Even the Ohio Attorney General has stated, even though we have constitutional carry, I think it's a smart move to go to a class. If you don't want to go to the sheriff's office and pay for the license, that's fine. But at least you go through the class and you learn some things that you wouldn't know. With that, I have to tell you a funny story. A friend of mine was doing a concealed carry class, and he had a pretty large class. And he asked me to come down and help with the range portion, the shooting portion of the class. So when I would come down, I would introduce myself in the class, and I would always ask people, why are you here? You don't have to be here. Why did you decide to spend $90 or $100 to come and take a concealed carry class? And generally what you hear is people say, well, I travel and I need a license because I'm going to be traveling around, or, I'm just here because I thought I'd learn something. But in this particular class, there was a young guy in the back of the room who raised his hand. I said, why are you here? And he said, a judge ordered me to be here. And all of a sudden, every eye in that class looked at him and thought, a judge ordered you to take a concealed carry class? He said, yes. I said, before we go on the range and put a gun in our hands, I need to hear the story about this. And I asked him, he could share with me privately. He says, no, I'll share with everybody in the room. He drives a truck. He was making a delivery to Michigan. On the way home, a Michigan State Patrol officer pulled him over for lack of a taillight on his license plate on his trailer of his semi-truck. When the officer came up, his company that he drove the truck for allowed him to carry a concealed weapon. So as soon as the officer came up to the truck, he informed the officer he had a concealed carry gun under the seat. Officer asked him to get out of the cab. First thing he said is, do you have a concealed carry license? He says, no, in Ohio, you don't have to have one. He said, but I'm sorry, in Michigan, you have to have one. He went to jail that night, had to get his truck towed off the highway, saw a judge the next morning, and he's the luckiest guy I know because that judge said, if I find you guilty of this, my guess is you're going to lose your job as a trucker. He says, absolutely. He says, and I'll tell you what I'm going to do. You go back to Ohio and take the class and bring your license up, and I'll expunge the record. I think that's the only judge in the world that would, right? So he was coming down to Ohio to take his concealed carry class, take the license. He already had an appointment with the sheriff when he was in the class to take that license back. He said the judge said he would expunge his record, but he wouldn't give him his handgun back. That he had to pay some price for not knowing what the law was in Michigan. So I looked at him, I said, you've also broken the record for the most expensive concealed carry class I've ever heard. He said, yeah, about $2,400 is what the towing of the truck, jail time, the attorney had to pay to sit in front of the judge the next day. So what a lesson to everybody in that room about why it's important to take the class, even though it's not required anymore. The other thing the judge told him is that in Michigan, you don't have to tell an officer you have the gun unless he asks. And he volunteered because he thought it was the right law-abiding thing to do. Ironically, the officer might never have asked him. But he, again, not knowing what the laws were, and again, not knowing what the law was in a state that he was in, which is important if you're traveling. So that is a great story. All right, so let's talk about the law a little bit. A lot of us think it's the law is what's written in a law book. It's written, but actually the law is not. It's a combination of a lot of things. As soon as I get my buttons correct. First of all, it is the statutory law that legislation passes, and it's written on an Ohio Revised Code, right? That's part of it. But it's also what we call case law. Courts start to look at that, and sometimes the law as it's written is very vague, and so courts have to look at it and interpret it. So that's part of the law. Then we get jury instructions, something that very few of us are familiar with, but in any self-defense trial, the jury is going to get instructions. Those instructions have been reviewed by judges, by prosecutors across the state, and it's the way to help the jury understand the law. So that's another form of the law. And then, of course, the last one is Supreme Court rulings from the United States, not just our own state, but a Supreme Court ruling like, if we have a little bit of time, I'll talk to you about a case in Ohio right now that's directly affected by the Bruin case that was in front of the Supreme Court out in New York State. So the law is a combination of all of this. And the problem is when you go to the Attorney General's website, you're just going to get the Ohio Revised Code stuff. Well, that's good to know, but the law is much more than that. It's a mixture. They put it all in a blender and it gets interpreted in courts, and it's just, not always black and white. So let me preview just some of the major changes that have occurred since 2004, and these are very common in all states. The law passes and then time goes and they realize they need to make it better. So let me just highlight a few of those. In 2006, there was a problem with cities around Ohio trying to preempt state law. So they passed a law saying cities can't do that. I mean, it became a mess because you thought you understood what concealed carry laws were in Ohio, but then you go to Cleveland and they made the laws different there. So obviously that needed to get fixed. I don't know why that wasn't in the original law. In 2008, Castle Doctrine was more clearly defined for home and included your vehicle. We'll talk more about that a little bit. In 2011, restaurant bar carry. Prior to that, you weren't allowed to carry a handgun in any place that served alcohol. With that law passing, you were allowed to carry your handgun in a place that served alcohol, as long as you weren't what? Drinking alcohol. So that's good, because it meant in restaurants I went to, I could carry my handgun because I don't typically drink, right? And if I knew I was, then I don't carry my handgun. I remember taking my wife for an anniversary dinner downtown and thinking, I have to leave my gun locked in my car and I don't want to travel between that parking lot and that restaurant. I'd like to have my gun with me, but I can't, because in that restaurant, the law prior to 2011 wouldn't allow me to do that. It also allowed a loaded handgun in a vehicle if you had your concealed carry license, which was weird that didn't get included in the first law, but that got fixed. In 2015, concealed handgun license training was reduced from 12 to 8 hours. How many went through the 12-hour class? Yeah, I did too. I taught many of those. Sometimes I split them in 2 days, but most of the time you tried to do it all in one day and watch most of the people fall asleep. Yeah. And that included 2 hours of range time. And then from a background check, we went to the NICS background check along with that. That's important because now at that point, if you had a license in Ohio, when you went to buy a handgun in a store, you didn't need to go through a background check anymore because you'd already been through one. So that was an improved background check process as well. Just a little side note on that. At the time, and I'm a fan of the NRA, but sometimes they do things that I'm not a fan of. Back then in 2015, they wanted to eliminate training in Ohio altogether. Said Second Amendment doesn't say anything about training. Well, the problem is if we would have eliminated it altogether, there's many states that you wouldn't have been able to travel in. We would have lost reciprocity with those states. because a state that required training was not going to let you come in with a license from a state that didn't require training. So it just wasn't the time to do that. We've gotten to that point now, but all right, in 2016, the law was passed. Handguns are allowed on school property if they're locked in a vehicle. I've got two asterisks up there to remind you that in Ohio, the only way you can have a gun on school property is you must have a concealed carry license. If you're going with constitutional carry, you cannot have a gun on school property. And that's very important. If you're dropping kids off or you're going to a football game and you have a license, you can lock up your gun in the vehicle and be okay. Remember, it's federal law that covers carry on school. But they usually give states an exception if you have a license. But obviously, if you're dropping a kid off, you're not there very long. If you're going to a football game, you've got to lock it up in a vehicle. So that came clear in 2016. 2018, this is a really important one, and I'll spend a little bit more time on this. The burden of proof was shifted to the state for a claim of self-defense. Prior to that, if you'd been arrested for the use of a handgun, you would have had to go to court and prove your self-defense case. We were the only state in the country that required that. And we got it changed. And now that burden is on the prosecutor. The prosecutors, they're the one charging you. They should have the burden to prove that. And that's significant. If you have to prove it, your expenses in the courtroom are going to be much higher. You have to bring expert witnesses in and things like that. As you can imagine, prosecutors in Ohio didn't like this, but I'll tell you a little bit more about that story. 2021, duty to retreat was removed anywhere you're legally allowed to be. Obviously, part of that was available with castle doctrine. And then another interesting change was a civil immunity was granted to nonprofits. So any nonprofit, a church being one of them, that had maybe armed safety people or armed security people, were always concerned about the liability. Well, that law removed their liability as long as the weapon had been used in a legitimate self-defense. The nonprofit couldn't be held civilly liable. And that was pretty important because there were a lot of churches that weren't allowing people to be armed in Ohio because of that liability existing. So that was removed. And it goes a step further. In 2022, by the way, duty retreat is often referred to as stand your ground. Florida learned that was a bad set of terms. Stand your ground sounds like you're in the Old West, Tombstone, and I'm going to stay in here and just fight you. You know, guns out blazing. That's the way it was written in Florida law, and they regret it. The legal basis is called duty to retreat. And luckily, we did not copy stand your ground. It's no duty to retreat. And that makes sense, right? If you're in a place you're legally allowed to be, and you're doing something that's not illegal, you shouldn't have to worry about fleeing. Prior to that law in Ohio, you had to flee, with the exception of your house and your vehicle. We'll talk a little bit more about that too. And then just this past year in March 2025, a law was passed that granted civil immunity to the person who acts in self-defense in a nonprofit. So the organization, it was removed. Now it's removed from the individual. So if I'm on a safety team at my church and I'm armed, if I have to use that gun, God forbid, as long as it's a legal use of self-defense, I can't be held civilly responsible, nor can the church. That's pretty important, right? So I want to hit a couple of these in a little bit more detail. The castle doctrine one. Here's the revised codes if you're that nerdy and you want to look at the written law. The problem I find with this is a lot of people think this is a get out of jail free card. Like, you're in my house, bang. I don't have to ask you questions, I can shoot you. Well, in one of my training classes that I took down at Tactical Defense Institute, John Denner, who was the founder down there, sadly we just lost him last year, would always ask this question. You're sitting on your couch at night watching TV, it's a warm summer night, your screen door is closed but it's not locked, and you're sitting and watching TV and somebody opens the screen door and walks in that you don't know. Could you shoot them? And everybody would go, yeah, they're in your house. Council doctrine. No, you can't. And if they say they're just there to steal your TV, just let them steal your TV. Could you point a gun at them while they're stealing your TV? Absolutely. But you could justify shooting them because even though they're in your house, they're not representing a deadly threat to you. Could be. But I can tell you, I know of 3 law-abiding citizens in Ohio that are serving more than 10 years in a prison right now because they shot somebody in their house because they thought castle doctrine was a get-out-of-jail-free card. And it's not. So you got to be very careful. I'll share just a little bit of detail here. Castle doctrine establishes that there is no duty to retreat if the person is lawfully in their residence or vehicle. It allows for a legal presumption of a deadly threat. If you use deadly force while in your home or vehicle, you must still prove that you reasonably believe that deadly force was necessary to prevent serious bodily harm or death, not protect property. And this is where castle doctrine can get really, are you protecting property? You're protecting that 53-inch new screen TV you bought or your life. This is important. That legal presumption is rebuttable in court. That means it can be challenged in a courtroom. And if you sit in front of a jury and you're trying to convince a jury you just shot somebody because they were stealing your TV, they weren't armed at all. Now, again, I want to be clear. I don't have any problem with you pointing a gun at somebody who comes in your house. The question is, where do you stand in terms of being able to shoot them? And there's people that think, I can shoot them. The law gives me the right to do that. Nope, you still got to meet some criteria. And trust me, the 3 people I know thought they were doing what was right, and they learned if prosecutor didn't believe that. Put them in front of a jury. So be very careful about that. The other one I want to look at is this one. This is one I got personally involved in, and it was really interesting. Ohio was actually the last state to do this, to shift the burden of proof from the defendant to the prosecutor in a self-defense claim. And I want to thank Margie Condit, who was our representative actually in this area, and Andrew Branca. Andrew Branca wrote a book called The Law of Self-Defense. Have any of you read it? If you haven't, you need to get a copy and read it and make sure you have the latest edition. He keeps it up to date. He's taken self-defense law and made it very easy to understand across literally all 50 states. Andrew is an attorney that specializes in self-defense type law. I read his book, and in the book, he made a kind of a nasty comment about how backward Ohio was because we were the only state that had this. I took the book up to Margie Condit in Columbus, sat down with her, said, we need to change this, Margie. This is not good. She read it, got some Congress people together, they put a deal together, and we ended up getting that passed. So you talk about how one person can make an impact. Like our previous speaker said, there's a great opportunity. I just went up and met with my representative and I said, we got to change this. This isn't good. Nobody else really in Ohio that lobbies for this had really decided to take that on for some reason. But they joined with us, Buckeye Farms being probably one of the best organizations in Ohio that helps us with legislation. So we got that passed, but it was really thanks to Margie for doing that and that book. And again, if you're carrying a handgun, you should have a copy of that book and read it. Duty to retreat, let's talk about that for a minute. The way the law reads is a person has no duty to retreat before using force in self-defense, defense of another, or defense of that person's residence, obviously counsel doctrine, if that person is in a place in which the person lawfully has a right to be. This is generally how it's written in almost all states. But there's a problem with this. And our legislators were getting ready to pass this the way it was written right there. The problem is a prosecutor can bring that up in a courtroom in front of a jury and say, jury, don't you think that person should have retreated? So it sounds good, but then when you get into a courtroom and see that it doesn't prohibit it coming up in a court, so a jury can say, you know, Bob really should have got out of there. He had a chance to run and he didn't take it. I don't want a jury having that. So what we did is we added this section to the bill. A trier of fact shall not consider the possibility of retreat as a factor in determining whether or not the person who used force, self-defense of another, or defense of that person's residence, reasonably believe that force was necessary. This prevents a prosecutor from using it in trial. I've been involved in one case where the prosecutor tried to use it, and I nudged the defense attorney. He immediately called the judge in chambers, and a mistrial was granted because the jury heard it, and the jury's not allowed to hear it by Ohio law. And I think the prosecutor knew it. He just wanted to find out if the defense attorney knew it. Sadly, the defense attorney didn't know it until I elbowed him. This is what we call hard stand your ground, or hard no duty to retreat. Don't quote me on this, but I think only 6 or 7 states in the United States have this written in their law. So when you hear that 40 states have no duty to retreat, the question of how many of them have hard no duty to retreat? Because without this added paragraph, it's really useless. Because if a jury or a judge can second guess you, that's not helping you in a courtroom. So that was really important. We got that added to that bill, and that was a big move. The nonprofit thing, I won't go into this detail, but obviously nonprofit organizations in which churches would be considered were granted civil immunity if somebody used a firearm in legitimate self-defense. That was big. Let's get out of permitless carry, because this is obviously very big. By this time, many states had gone to constitutional carry. 29 states, as of the end of 2025, have constitutional carry. That is, as long as you're law-abiding, and I won't bore you with the big definition of that, and you're 21 years old in Ohio, you can carry a gun without a license. You still hear me say, I recommend you go to the class, even if you don't get the license. I think you need to understand a little bit more about the law than just, hey, I can do it because I have a right to do it. I'm a big fan of still going to the sheriff's office and getting one and carrying it with you. You don't have to carry that license anymore after this law. You don't have to carry it. You also don't have to tell police you have it. They have to ask you. Now, let me tell you why that was significant. Prior to then, if you were carrying a gun in a car and you got pulled over, you had to tell the police officer that you had the weapon. Very few people know this, but that granted the officer a right to search your car. Most of them didn't unless they smelled marijuana or they smelled alcohol, but in some Supreme Court rulings, they would be allowed to search your car because a weapon's present. And so I would always say to somebody, what if your teenager was using your car over the weekend and one of his buddies stuffed a joint in the back seat, and now the officer's doing a search of your car, brings the dog out and finds a marijuana cigarette in the back seat of your car, and you're carrying a weapon? You're going to lose your weapon. So when the law was changed, a lot of people that were in my classes would say, well, I'm still going to be a nice person and let law enforcement know that I have a gun. I said, no, don't. I'm pro law enforcement too, but don't tell them. Make them ask. Because when they ask, they can't search your vehicle anymore. When you tell them that you're carrying a gun because they ask, they don't have a right. Now, obviously, if there's marijuana or alcohol, they still have a right to search your car. All right. But those would be legitimate reasons anyhow. So that's the little subtleties of the law that, I've even sat in concealed carry classes where the instructor didn't mention that. And I think, I get pulled over. I speed, not a lot, but it happens. Okay. And then this last one, the civil immunity was granted individuals. No person, so originally it was no nonprofit organization, now is liable for tort action. Again, if it's legitimate use of self-defense. So this is a question I get with a lot of church teams. Churches were always pushing back on, well, we can't have people carry because there's liability. Our insurance company at the church won't handle it. That excuse is gone. The organization has liability and the individual has immunity now, as long as the use of the handgun is considered legal form of self-defense. So that the pushback that I was getting from churches to maybe arm people on their team. I'm sure you all know, or you're aware, I hope, that Ohio is still one of 6 states that requires permission to carry in a church. So again, here we find ourselves one of only 6 states that requires that permission. I've said that in many churches, and people were like, wow, I've been carrying my gun here for a long time. I didn't know that. I thought we were allowed to carry a gun anywhere. No. That's another reason you take the class, so you find out what places you're not allowed to have a gun. Well, I figured a jail was a place, and post offices, and and churches too. It's usually a misdemeanor, but it could go all the way to a felony. So you don't want that. So churches are required to grant permission. The law doesn't state this, but I'm a fan of that permission should be in writing, and it should be for a year. meaning you have to renew it every year. And I would not give permission at any church to somebody who doesn't have a concealed carry license, even though we're a constitutional carry state. I want to know that person's been through a class and has done a little bit more. Most churches that I work with, we have everybody who's been given permission, or before they get permission, they must pass the Ohio police officer's shooting qualification, the OPATA qualification. It's not a difficult one, but at least it indicates that you've passed the test that Ohio police officers have to pass. Generally, my church team, they have to pass it twice a year. And then if they don't pass it, that permission is removed until they move. I think that's a good standard. It's obviously one we use with school teachers that we arm in Ohio. In fact, we even added an additional stage to the OPATA qualification for school teachers, but school teachers have to pass it, and they have to pass it twice a year. Ohio police officers only have to pass it once. So I think it shows for a church that they've taken this seriously. They're not necessarily going to grant you permission because you have a gun. You have to kind of prove that you know how to use it. Not that necessarily the OPATA is a good proof, but it's at least one that's recognized around the state. A couple of my churches, I actually use the FBI qualification with, which is obviously a much more difficult qualification, but it helps with any liability concerns that we would run into. Yes, we did get permission. It's in writing, and they did pass this test before we gave them the permission. And we only give that permission for a year. And if they don't maintain that standard, we'll remove it. Great on time. So I want to share with you some impact of the Bruin case. This one occurred actually in Ohio. Circumstances like this are, so this was New York State Rifle filed a claim that got all the way to the Supreme Court. Supreme Court ruled very favorably on the Second Amendment. What the Bruin case said is lower courts have been told that when they review a firearms-related law, they have to keep two things in mind. One, if the Second Amendment's plain text covers an individual's conduct, then the Constitution presumptively protects that conduct. So that's one of the tests. The second test is an interesting one. Any regulation that the government tries to impose on that conduct must be consistent with this nation's historical tradition of firearm regulation. So you go all the way back to like 1776, right? So let me give you a case that's going on right now up in Montgomery County, just to show you how this plays out. A young girl got pulled over on a traffic violation, I believe it was, under the age of 21. She had a concealed handgun in the vehicle, loaded. Informed the officer that she had. She immediately got arrested for having a handgun under the age of 21 years old. Her attorney, who I've tried to talk to this week, but he's not returned phone calls. Don't know why he did this, but he decided to go to Ohio's appeals court and say, based on Bruin, she should have a right, even though she was under 21, to have a handgun. The Ohio's appeal court actually ruled in his favor. By the way, she was 10 weeks away from being 21, but I don't think this played into it at all. And the Ohio appeals court actually ruled that under the Bruin Supreme Court ruling, 21 is not the legal age. Isn't that interesting? Because now it's got Ohio in a bind. Right now in Montgomery County, you can carry a handgun under 21 based on the appeals court ruling. I wouldn't recommend that in any other county because the appeals court case just applied to that county. But that county right now is not under the 21-year-old regulation. In the Bruin case, they said, if you're allowed to enter the military at 18, you're considered legal to sign contracts at 18. You can leave your house and not be part of your family anymore at 18. Is the legal age really 21? And if you look back in historical history, 18-year-olds were learning how to shoot guns in school and joining militias. So there's not a history in the United States of 21 being the legal age to buy or carry a concealed weapon. So this has got Ohio in a bind right now because the latest legislature in Ohio now has to address this. By the way, it got appealed to the Supreme Court, and Ohio Supreme Court said, we're not even going to look at it. The appeals court is right. Based on the Bruin Supreme Court case. By the way, I have the appeal ruling here. I was looking at it on an airplane this week on the way out to San Diego. My wife said, "You're a nerd." The trial court found, and they referenced the Ohio Revised Code, are unconstitutional as applied to Mitowski. According to the trial court, sustained Mikowski's motion and dismissed the concealed carry and improper handling of a firearm, which he also got charged with for having a loaded firearm in her vehicle, against her. And then they go on to explain, based on the Bruin court ruling, 21 years old is really an arbitrary number. I'm not even sure you can make the case that 18 years old, but with signing legal contracts and being old enough to be in the military, 18 sounds like it's historically been the age of consent. And they go on to that. They say individuals who are between the ages of 18 and 20 are not minors today. They have the right to vote. So why are you limiting them from carrying handguns? So in a minute, I'm going to share with you a couple bills that are going through the Ohio right now. And one of them is to at least allow 18-year-olds to buy handguns. In Ohio right now, the law is you can't buy a handgun unless you're 21. But they're now going to have to address this. And I'm going to bet that next year in front of the governor is a bill to reduce concealed carry in Ohio to 18 years old. Because, and this is how court cases like the Supreme Court affect laws. It's very clear here this appeals court didn't, and by the way, this is a Democratic appeals court. I don't get politics too often, but this is not what you expected from this court, to say she's not guilty. She has a right to have that handgun, even though state law says 21. The Bruin case says no. So it's really interesting. Just read something else. It says, in some history suggests that, meaning the history of the United States, that individuals aged 18 and 20 were not deemed too dangerous to bear arms at our founding. I'm getting a lot of amens from just, okay. So it's really interesting. Yeah, I'm a little nerdy on stuff like this, but it's important to understand how the laws come about. And that's going to be a significant change in Ohio. Indiana, if you aren't aware, allows somebody 18-year-olds right now to carry a concealed handgun. So that's, and let me tell you, if that changes in Ohio, it will sweep across the United States. It will. It may take a court case to make it happen, because states' legislatures aren't so quick to change things until a court tells them that they have to. But if you look back, that's how we actually got concealed carry in Ohio, was because of that court situation. So little details. Whoops, I'm sorry. I didn't put them, whoops. No, I just shared them with you. I didn't put them up on a slide. So let me tell you what some new proposed laws are in front of Ohio right now. This is a really important one, House Bill 108. It's called a pretrial immunity hearing. Has anybody ever heard of this? I'm not sure how many states have it. What this is if you've used your handgun in self-defense and you've been charged, this bill would give you the right to meet with a judge, prosecutor, your attorney, and the judge, no jury involved at this point, present the evidence, and if the judge says, yeah, this was a legitimate self-defense case, then it never goes to a courtroom. Let me tell you what one of the downsides of that are. Once you go in there, you've presented your whole case in front of the prosecutor. If the judge says, not sure this was a legitimate self-defense, and you go to trial, your whole case has been laid out in front of the prosecutor. So the risk is, if you think it's a legitimate self-defense shooting, this is a lot cheaper than going to trial, right? But you run the risk of the judge saying, not so sure, I think we ought to put this in a trial. Well, then you've laid out your case again to the prosecutor. So there's some pros and cons about this, but I'm not sure where this is going to go. This proposed law has been written by an attorney up in Toledo who's had a lot of self-defense cases and saw what the expense was if it went to a trial and thought, immunity hearings would be helpful. Florida has this, and there's been a number of cases in Florida that were very public that went in front of a judge in a pretrial immunity trial, and the judge said, this is legitimate self-defense. This person, we're not going to go to trial. They're not guilty. Can you imagine you sitting in that courtroom hoping that judge is a good judge and kind of likes guns? Yeah, and that's the risk you take. And some attorneys would say, because I know the judge we're going to do this in front of, and maybe this isn't a good idea. Maybe we just need to go to trial and get in front of a jury who might be a little bit more friendly to you than. Another House Bill 68. Lawmakers want to carry their guns in government buildings. So this is, I don't know how this is going to come out. Right now, government buildings are off limits, but there's some lawmakers who would love to carry their guns when they go between their car. Sometimes it's not so much like restaurants that I mentioned earlier. With the building, it's the travel between where you park and the building, which is where your danger zone is at. Or when you leave the building and go to your car, right? It's not that I worried about getting attacked in a restaurant. It's the trip between the parking garage in downtown Cincinnati and the restaurant, and the other part of that trip that would be where I'd be most at risk, but because I can't carry in a restaurant, or at least up until that law was changed, I want to be able to carry a gun in that restaurant. It's funny, there was a state, I can't remember who it was, it might have been Arizona, that was actually thinking about if a restaurant's not going to let you carry, they have to provide a place where you can lock it up when you get there. So at least you could carry it to the restaurant. They have to provide a place to lock it up when you're there, then you can unlock it and take it back to your car with you. As a way to say, hey, if you want to play that game and put your place of business off limits, at least you have to provide a place to lock it up so that the person in the way to get back and forth can have their gun with them, right? Because that's generally where the crime occurs. This tax bill, I'm not all that familiar with it, but it will give a tax credit for handgun. I think this is a way to encourage people to take concealed carry classes, and I don't know where this is going to go either. This is the one I mentioned to you earlier, Senate Bill 303, which will allow 18 to 20-year-olds to purchase handguns. I'm pretty sure this is going to pass in light of the Bruin case. You can't tell 18-year-olds, and if this passes, then why can't they carry the gun if they can buy it? It's almost unnatural. So I think we'll probably see the carry one maybe even combine with that eventually, so that when that bill goes through, it covers both concealed carry and purchasing a handgun. Because you don't want to let 18-year-olds carry a handgun and have a law that says you can't buy a handgun until you're 21. That wouldn't make sense. So I think those go together. This is an interesting one. Senate Bill 278 allows citizens to seek damages against cities that pass gun control measures. Now, if you remember earlier, one of the laws that occurred, how afterwards was to tell cities you can't make laws different than the state. All right. But guess what they're still doing? Cleveland being a good example, that still likes to write laws that are, even though they're in violation of a law in Ohio that already exists. So this is going to clarify it, and you can place claims against those cities if they've done it. So I'm just making this example up. You can carry a handgun in a restaurant right now, as long as you're not drinking, right? So let's say Cleveland says, we don't like that. We're going to change the law in Cleveland. Can't carry a gun in a restaurant. Well, they're already in violation of Ohio law by doing that at the city council or commissioner level. But this is going to allow you to seek damages from them if they do it, which will be hopefully an encouragement for them to quit doing it. That's what this is all about. We still have cities around Ohio that are misbehaving. And we're in the process of drafting a bill right now to remove the permission to carry in houses of worship. The governor originally said he wouldn't sign this. His wife's not for this. She thinks still limiting. The fact that we're one of only 6 states that still has this requirement tells you we're a little bit behind. But so one of the questions I get a lot from churches, I actually am okay with the law as it stands. I like that you have to get permission, because then you kind of know who has a gun in your church. Well, you hope you do. The problem if this law passes, if you're on a church safety team and an incident goes down in your church, and they're rare, trust me. I'm not sitting here making this sound like this is a big occurrence. They're very rare. But if they do, you're not going to know who's going to stand up in that church and start pointing guns at people. As we saw in Texas when there was a shooting that occurred and people stood up, because in Texas you're allowed to have a gun in a church, and they all pointed guns at everybody in violation of a lot of handgun rules. So I kind of like this rule that if you're going to carry in a church or place of worship, you need to get permission from the church. That way the church can establish some criteria. I can see it both ways, actually. I still tell churches, if you're going to have a safety team and you're going to allow people to be armed on that team, even if this law passes, I would still have some criteria for that. Some of you may be aware of this, but the self-defense insurance world has addressed this. In a lot of the self-defense insurance companies, if you're carrying on a church team, they won't cover you unless you get another one of their policies that's usually higher priced. They've recognized that there's risk associated with being on a safety team and carrying a weapon. You're more likely to maybe have to use that weapon. So an insurance company would say, well, then got to pay a little bit more for your insurance. Or churches, you can buy insurance to cover your team members while they're at church and armed. So when the insurance companies reacted to that, that tells you that they recognize if you're armed on a church team, you're probably at a little bit higher risk. Or if you live in some neighborhoods of Cincinnati, maybe they should charge you more. So that's what's in front of us. There's a lot of other garbage that's out there, as there always is in legislation sessions, pro and con, but that's some of the things that are in front of us. This is the way the Ohio church carry law currently reads. A valid license does not authorize the licensee to carry a concealed handgun in any of the following places. Of course, any church, synagogue, mosque, or other place of worship. There's a whole other list. That's number 6. Or permits otherwise. Again, we're a constitutional carry state, but look how that law reads. A valid license. So I've had to tell churches, are you giving people permission to carry in your church that don't have a concealed carry license? Because the law still reads license. The law hasn't been updated to constitutional carry yet, obviously. I don't think that was intentional. I think they should didn't. So this is the one that a court will have to deal with. Somebody on your church team constitutionally carrying has to, God forbid, use that handgun in the church, and they don't have a license. Prosecutor could go after him based on the way this is written. And then so it happens to get appealed maybe 4 years after the original trial. So you're doing jail time until that point. But that's how laws work. I wrote an article on this topic, so to save you time, if you go to that QR code or you go to Buckeye Farms website, you'll find that article. I wrote it back in 2024. Thoughts on how places of worship should handle concealed carry permissions. I've worked with churches all over the country. I've had the opportunity to work with 2 churches that actually have had shootings, because the big question that they can answer that nobody else can is, what would you do differently now that you've actually had an incident at your church? Looking back, what would you do differently? And the other thing is, we spent a lot of time talking with insurance companies and lawyers, because all of them get involved in a church shooting, and asked, what's the best way to handle this? And I tried to put it in a really concise, short article. Interesting that if you go to Buckeye Farms, a lot of articles get published. Some of them get maybe 500, 700, 1,200 reads. Last time I checked, this had 5,000 times people have clicked on it. Okay, I did it one night a lot, but no, I'm just kidding. And if you don't know how to use QR codes, there's the, I'm sorry. I did a podcast on it. My friend, Rob Beckman. Rob couldn't be here tonight. I know he's online. Rob's a good guy. Rob's, by the way, a local guy running for the NRA board. And he's the kind of guy we need on NRA board. Really solid guy. After Rob read this article, invited me to be and do a podcast on it. So if you're interested in podcasts, we did a podcast where we talked about this article a little bit. As I close out, I want to share with you, since we've had concealed carry in Ohio now 21 years, we've got what kind of trouble do civilians get into? I'm talking law-abiding civilians get into. Anyone guess what the number one is? Legal issue that law-abiding concealed carry people get into? Brandishing. That's pointing a handgun at somebody that didn't deserve it. It's the number one. You talk to any attorney in the United States or in Ohio, they'll tell you, from a law-abiding concealed carrier, that's the number one issue they're dealing with. It could be as a result of a road rage. They pointed a gun at somebody. Even we've had people in Ohio that somebody was in your house, they pointed a gun at, and the person that they pointed a gun at came back and filed charges against the homeowner for pointing out. Obviously, those are going to get dropped because you'd be allowed to do that in your house under council doctrine. But brandishing. I'll give you a quick example of this. I was teaching a class one day, and we were going over this, and a lady and a husband were together in this class, and she kept elbowing him. And at break, I said, "Do you want him to tell us something? What is it?" And she said, "We just had an incident in our house, and I'm not sure my husband handled it the right way." So he told me what the story was, and I asked him if he wanted to share it with the class, and he said he would. So here's the story. They live out on the east side of town, kind of rural. When they get home one night about 10 o'clock, he dropped his wife off at the house. About 50 feet or so away was the barn where he parked the car. So he dropped his wife off, went to the barn. When he was getting out of his car, he heard a motorcycle go past the house. Very rare that he ever hears a motorcycle, so the motorcycle caught his attention. He stood at the end of his car, watched the motorcycle turn around and pull into his driveway. Maybe about as far away as Betty and I are. He parked, turned the motorcycle off, took his helmet off. This guy had a concealed carry weapon, not the motorcycle guy, we don't know. He took that gun out and put it behind his leg because he just wasn't sure. He asked the guy what he wanted, and the guy said he was looking for directions for a place. And the guy said, "I have no idea where this place is. You're really lost. So you need to get on your motorcycle and leave." Gun still behind his leg. Then the guy said, "Well, I actually need some gasoline." At that point, the handgun came around the front, and he said, "You need to leave." And the guy put his helmet on, started the motorcycle up, left. He went into his house. As soon as he got in his house, his wife had watched all of this. She said, "You need to call the sheriff." And he said, "Why?" She says, "Honey, you had your handgun out." Well, no. So he didn't. So the question that he wanted to ask was, should I have? I said, "Well, this is the part where I'm not an attorney." I said, "But I will throw a scenario out. What if he would have got on his motorcycle, driven down the road, stopped, called the sheriff's office and said, 'I just pulled in a guy's driveway looking for directions and gas, and he pointed a gun at me.' Tell me what you think the sheriff's going to do." He's going to come down and arrest him. That's a aggravated assault charge. He would have no choice. Even if you're the most outstanding citizen in the neighborhood, he has to come down and arrest you based on that phone call. Could he have made that phone call? Absolutely. Let's go one step further. God forbid he goes down, pulls in another driveway, robs, beats, and maybe even rapes a neighbor. And you never called the sheriff? You were suspicious enough of him to show him your handgun, but not suspicious enough to worry about, well, he got out of here, but what if he goes down to a neighbor? How bad would you feel? You wouldn't be legally responsible, but how bad would you feel if you learned that the next day? That the guy you forced out of your driveway went down and did some terrible thing in the neighborhood. I don't know if you're rural, you're allowed to say neighborhood, but anyways. He said, "Well, I never thought of that." I said, "You should have called the sheriff." They probably would have taken a report over the phone. They may even have sent a cruiser out looking for the motorcycle guy. But you were concerned enough to show him a handgun. By the way, that's brandishing in Ohio. If I even go like this and show you my handgun, that's brandishing. I don't have to pull it out and point it at you. Some states, the handgun actually has to be pointed at the person, but not in Ohio. I just show you. Or if I even say, "Hey, got 9mm sitting right there. If you want to have this," that's can also be considered brandishing in Ohio. So you got to be careful. Second, road rage, which often leads to brandishing. But I mean, even in this area, we've had some law-abiding citizens get in big trouble because, you just don't like people cutting you off. And you have a gun in your car. So they start walking back. You pull out your gun, point it out the window and say, "Get back in your car." And that person calls the police and say, "I was walking back to the car to call them a bad name and they pointed a gun at me." To actually use your gun in that situation, you'd have to be attempting to break into your car, not just walking to your car and calling your mother names. It actually has to be, they're pounding on your car, trying to get in. At that point, you could probably get your handgun out and show it to them and say, "Breaking into my car is probably not a good idea." But before they get to your car, you're pointing a handgun at them, especially out the window, not a good idea. Defense of third parties is another one. You come upon a fight, you don't know who started it. Case in mind, I can't remember exactly the state, but it was a neighbor who saw a couple in his neighborhood fighting. The man was really beating up the woman on the front yard. He came down, pointed a gun at the guy. The guy didn't stop, so he shot him. Problem with that? The wife had started the fight. She threatened her husband with a knife. And he was just responding to her initiation. She wouldn't have had a right to use self-defense because she initiated the situation. So he didn't have a right to use self-defense for her, and he didn't know that story. So he didn't get found guilty, but man, he went through a lot of money, over $100,000, which is another good reason to have self-defense insurance. And most attorneys in this state will not even talk to you without a $20,000 down payment, or at least have an insurance company that will cover that for you if you've been involved in a shooting. The fourth is firing unnecessary shots. I was involved in a case up in Toledo where a guy legitimately fired a couple shots, and then a few minutes later fired 3 more shots. Those shots were fired in a parking lot at the guy, but they never hit him. The prosecutor in Toledo charged him not only with murder, because the guy he shot the first time eventually died, but he charged him with 3 felony counts for the 3 additional shots that he fired a few minutes later. The jury, believe it or not, legitimate self-defense case, found him not guilty on the murder charge, guilty on the 3 shots he fired. 3 felonies, 17 years in prison for the 3 additional shots he fired. So any firearms instructor that told you mag dump is okay, please understand you are going to be accountable for every shot you fire. And if a prosecutor who's not friendly to gun people thinks you fired shots that weren't necessary, they'll come after you for those shots. Remember, he was not guilty on the murder charge. I don't think he should have ever been charged with that, by the way. I thought it was a legitimate self-defense. On the 3 extra shots, I said it's up to the prosecutor what he's going to do with that. And this prosecutor charged him. So be very careful about mag dumps, please. Fire the shots, and that's hard when the adrenaline's going and your finger's on the trigger and you know you got a 17-round magazine and somebody's threatening your life or serious bodily harm. But you got to be aware that we've got judges out there pulling that. Defense of property. You cannot use a firearm to defend property in the United States except in one state, Texas. And the way that law is written is only after dark. So only time you can use a firearm in Texas to prevent a piece of property is after dark. Isn't that cool? They don't define what time after dark is. Remember how I told you laws get written and then judges and courts have to define them? I was involved in a case down there where a guy in an apartment heard an alarm in his truck going off after dark, opened up the second story window, told the guy to get away from his truck. I mean, trucks are valuable property in Texas, as they are probably everywhere. Guy didn't get out of the way, pulled out his rifle and shot and killed the guy. Police came, investigated, didn't even charge him. In fact, the story goes they helped him wipe some of the blood off his truck. That's Texas. It's a different state. Okay. So you got to be really careful about this. Defense of property. And then the last one, they get arrested in another state because they went to a state and didn't understand that state's laws, like my friend in Michigan. Don't do that. If you travel, you need to be aware. So I'm going to give you a couple websites. I think I've already made the case that if you're carrying a handgun, you probably ought to have self-defense insurance. I'm not here to recommend one. There's a lot of companies out there. They're growing. Just do your homework. The one I use, I pay about $400 a year. So it's like car insurance. But I have it because I know what the cost will be if I ever have to use my gun. A judge is not going to say, hey, go home, Bob, you're all good. You're going to have an attorney. That judge and prosecutor could string this out for 3 or 4 months. So unless you got, buku dollars sitting in a checking account or a big Venmo account, probably ought to look at it. These are 2 websites that I found very helpful. You can buy them or get them as apps on your phone. And if you're traveling, you can look up the state you're traveling in, and those websites tell you what the law is. And if you tell that you're an Ohioan, it will tell you specifically why that state or how that state's different than Ohio. And you got to have that because, listen, states on handgun laws across states are way different. In Ohio, we have no alcohol, correct? Tennessee, as an example, uses, I believe, the legal limit for driving. So you can go to a restaurant, drink, as long as you're not over the driving limit, you can still have a concealed handgun and be legal. So that's one you ought to look at, even though I don't think alcohol and guns ever go together, but some states are different there. So be aware of that. Those are two good apps. And then handgun.law US is, I don't know if they have an app, but you can always go there and check. Do it before you travel. I know a guy who's getting ready to go out on a big trip out west, and he's gotten on there and looked at every state. Him and I had a conversation this week. He's driving through Illinois. I said, then you just better drive straight through Illinois. You even stop for gas in Illinois with a concealed handgun, even if it's unloaded and in your car. They find, if for some reason the policeman comes up to you. So I'd get gas before you go to Illinois and just drive straight through Illinois. New Jersey is another state you don't even want to go into with a concealed handgun. You can imagine what some of the other states are.
Bob, can
Yes.
we take some questions?
Yeah, we're right there now.
We got a question online. Well, we had a question online. Let's take one here in the studio first.
So it seems to me, sometimes criminals will come in more than one person. So they might come in groups or 2 or 3 people. They break into my house. What if I use something like a Byrna or a non-lethal option? Is that viable, or is it still better just to do nothing if they're just stealing property?
Well, you got a big advantage if they come in as a group, because disparity of force can be to your benefit to legitimately use self-defense. By the fact that there's more than one person. A good example of that would be, let's say I'm in a wheelchair at my house and anybody comes through my back door. Just the simple disparity of force would give me the right to use deadly force because that disparity is so great. Okay. I was hoping the Byrna question would. I'll tell you what I don't like about Byrna. It looks like a handgun. I don't care what color they make it in. It looks like a handgun. You point that at me, I have a reasonable belief you're pointing a handgun at me, you're going to get a real handgun pointed back and shot at you. In your house, you could get yourself in a gunfight by pulling out something that looks like a gun but it's not, and the bad guy gets a gun, sees that and perceives it to be a gun. And by the way, any reasonable person would perceive that to be a handgun, especially if it's in a holster on your waist. You bring that out. I don't care if it's purple, green, or whatever. Handguns are made in all colors. And I perceive that to be a real weapon. I'm going to bring out a real weapon. You hit me with a pepper spray ball and I hit you with my 9mm. I don't think that's a fair fight. I'm not telling you not to buy the product. It's a great product for law enforcement and military because they're allowed to point things at people. By the way, this is an issue I see in concealed carry classes that are taught by law enforcement. You know, law enforcement is allowed to point guns at you. They don't get charged with brandishing. We can't do that as a civilian. So I'm very cautious to tell people, be careful who you point guns at. Police officers can do it, and they're immune from it. And their job is actually kind of required sometimes to get somebody to behave. Bring out a real gun and point it at him. Tell him to get out of your house. Tell him to get out of your house. By the way, council doctrine in some states Ohio's not one, but requires an actual violent break-in. So Maryland, for instance, the break-in has to be violent. If they just simply open up the screen door and walk in your house, council doctrine doesn't apply there because you made it easy for them to walk into your house. It has to be a violent entry. Ohio's not there, but I dealt with a case.
Let's take our online question.
We have 4 now. So the first one, if you come upon a life-threatening situation, are you required to warn the perpetrator before taking lethal action?
No. As long as you're justified to take that legal action. The best thing I tell people in my classes is whenever you can outsource your violence to 911, do it. Outsource your violence to the police department, right? If I see 2 people fighting out there and I don't know who started the fight, even if it's a woman who's getting beat very badly, I don't know the circumstance. I'll get on the phone, call 911, tell the person I've called 911. Hopefully that ends it. But I'm certainly not going to draw a gun and point it because I don't know who, if I'm justified to do that. Police officer could do that, but I don't have that ability. So I have to walk away and call 911 and outsource the violence to the police department and let them come sort it out. Unless I know who started that fight,
Next question is, why did he fire 3 extra shots?
He saw that when he came back out after the first shooting, he went in because he realized he left his cell phone in a pizza place. He came back out. He saw the guy trying to get into a car, and he thought maybe the guy was trying to get a gun. He didn't know, but he fired 3 extra shots. And those shots didn't hit anything but the parking lot and the car. But prosecutors now, they're not gun friendly, will go after those 3 shots. Yeah, the guy he shot actually didn't die. I don't mean to sound cold on this, until like 2:00 in the morning in the hospital. So, and he was a defensive lineman for the University of Toledo football team. So you can imagine he was a pretty big guy. 3 shots in the chest. He didn't die until early in the morning the next day. So all of you that think, as Hollywood teaches us, you get shot, you're like down and out. Not in real life. Amazing what I've seen people do with gunshots, even in the chest. Another one?
Can a burner be taken on church property without permission?
Yes, it's considered a non-lethal instrument. I would recommend normal pepper spray, something that you pull out of your pocket that doesn't look like a gun. That's what I'd recommend. And I even recommend highly, if you carry a concealed weapon, you should have pepper spray on you at all times so that you have something between a curse word and a mag dump. Because you may be in a situation where the gun's not justified, but pepper spray, not that I would pepper spray my friend Keith, but I could pepper spray Keith, and even if I'm mistaken, I'm really not going to be legally accountable for that because it's not considered lethal. So yeah, and you have, in Ohio, you have to be 18 years old to carry pepper spray. So
we only have time for a couple more questions.
okay.
I got one more.
Keith he wants to know why I'm pepper spraying.
Let's take one in the studio next.
Yes, Michael Bruin, is he in the courts, Ohio courts? Is he a court person?
I'm sorry, the name?
Michael Bruin or Bruder?
I don't recognize. The Bruin?
The Bruin case.
No, the Bruin case was a case that came out of New York State, filed by the New York State Rifle and Pistol Club. I can't remember exactly. I'm not sure. I think Bruin was the name of somebody, but that's how by the time, like in McDonald case that came out of Chicago, that went to the Supreme Court. McDonald is what they refer to it. Bruin is what the New York case was. Yeah. But once the Supreme Court ruled, that ruling now applies across all the states. So any state that right now is not allowing people under 21 to carry a concealed weapon, Bruin's made really clear, the Ohio appellate courts helped.
Thank you.
You better start changing that.
My question I actually had was jury instruction, that and also the Rule 108 or 98 or whatever you said, where there's a prosecutor and a judge and you. Isn't that like a biased hearing? Could you bring in a lawyer? Thank you.
It's 2 lawyers are in that room. If it's a pretrial immunity hearing, it's literally like a court case, except it's just you, defense attorney, the prosecutor, and the judge. There's no jury there. I mean, there's a steno there taking notes. Yeah, your lawyer's there. Yeah, making the case. What was your what before that? What was your
Instruction?
Yeah.
You can't do that.
This is uncanny. I've seen more self-defense appeals, meaning they went to court, didn't win, and the appeal was based on the judge not giving the jury a self-defense instruction because the judge didn't think it was self-defense. And that's often a very legitimate appeal. Then the appeals court looks at the case and says, you know what? The jury should have got it self-defense. Even if there was questionable if it was or not, the judge should at least given the jury a chance. But obviously the jury can't if they're not given that in their instructions. I see more appeals across the country based on that one thing, that it should have been a self-defense case up front, but for some reason the judge didn't allow it, therefore jury instructions weren't allowed. The person was found guilty, they went to appeals court, and the appeals court looks at the whole picture and comes back and says, yes, they should have got self-defense jury instructions. Because of that, they're going to force a retrial. Then they have to decide if they're going to retry it or not. So meantime, you're sitting in jail for 3 years, maybe waiting for the appeal process to come down, all because a judge didn't do the right thing. And by the way, judges in the United States often don't do the right thing. They have bias too. And that bias is often shown when they don't give a jury self-defense jury instructions in a case that may be questionable, but let's let a jury figure that out instead of a judge, because I asked for a jury. By the way, you can get tried by a judge and without a jury too. So
We are 15 minutes over time, so we're going to have to end.
always are on this topic, aren't we?
Yeah. I'm sure Bob will be around for a few minutes if you have a question, but that was really great. A lot of good information.
Thank you.
We thank you so much.
Thank you.